Okay, so let us start our professional practice. So today I will do the supplementary paper 2024. So if you guys have a look at the questions already, I will go through the question one by one. If you guys have any question, then you can type in the chat box, then I will answer accordingly. Okay, so ABC Terang was placed in judicial management by an order of the High Court, and its appeal to the Court of Appeal against that order was dismissed. So, do you guys know what is judicial management? Uh, Judicial management actually is one of the we call corporate rescues mechanism. So there are three types of corporate rescues mechanism we can apply lah. So judicial management is one of the type lah. So the other two is like scheme of arrangement and voluntary arrangement. So these three things basically is more like, when a company, when they are not uh, able to pay off their debt, then you may apply to the court to say that ask all the creditor don't sue you for a certain period so that you can have the sufficient time go and negotiate with all the creditor so that your company won't be wiped out and all the proceeding will be stay lah. So judicial management. So here ABC Bank was placed in this judicial management. So then it has filed an application for leave to appeal to the court appeal. And I think most of your guys should know, right? If you want to appeal to federal court, it's not as of right. You need to get the leave of court. So there's two requirements. Is number one, the issue has never been decided, and number two, the matters must be start from High Court. The assistant solicitor for ABC Bank has discharged themselves. Okay, Leon, the in-house legal counsel for ABC Sdn Bhd was tasked with the responsibility of engaging a new firm of solicitor. Okay, so Leon has met up with Danish, an advocate and solicitor of the High Court of Malaya, who agreed to be briefed and suggested to Leon that Pillai, a senior counsel from Singapore, be appointed to conduct the proceeding at the federal court on the basis that Pillai is the leading authority on the subject of judicial management of financially distressed company, and that provision of Malaysia Companies Act 2016 have their origin from Singapore Companies Act 1967. Okay. So Leon has now seek your advice on the possible admission of the senior counsel from Singapore. Leon is also concerned Pillai is not conversed in the Malay language, advised Leon. So basically in this question, they are asking you, if we wanted to so-called hire a foreign lawyer to practice in Malaysia, is it okay or not? So I think you guys will know, right? There are 4 types of admissions in Malaysia if you want to practice as a lawyer. So number one is the most, I would say, classic the most general one You must be a qualified person first, then only you can practice in Malaysia. So what is qualified person? It is if you graduate from UN, NUS, you study bar. I think nowadays they don't call PPTC already. Last time when you study in UK bar, they call PPTC and which is you guys CLP student. So when you have either one of the qualification here, then you are the so-called qualified person. Then after you do your pupillage, all that, then you will become admit as an advocate and solicitor So this is the most classic one I say. Then second one is admission in special cases and admission with special admission and foreign lawyer. I just quickly explain what are the differences So this one is the most general one. This one, admission in special case remember when we say admission in special case you can also known as ad hoc admissions. So what ad hoc means, like they only admit you to handle this case only. Once you've done this case, then you cannot practice in Malaysia for other case. So this second type will be more suitable to our questions because they will just want Pillai just to add for this case only So I think we can use the second type. And the third one's for admission with special admission is more like, I think you can understand in the way like a person who used to work in the judiciary, for example, a PP or a judge, when they retire, takkan you ask them to become a pupil for 9 months. In fact, they know more than you. So those special people, they don't need to go through the first type, the qualified person. When you work in the 7 years in a similar area, usually here we refer to judicial and legal services those like judges and PP then they get admit as a lawyer and practice as a lawyer. And the last one is foreign lawyer. Okay, so the question now is, can we apply these special cases to allow Pillai to practice as a lawyer in Malaysia. So in this one, I would like to highlight a case to you guys is, just a moment. That case actually is related to our ex-Prime Minister Najib lah, because she wanted to appoint a Queen Counsel lawyer from UK to help out his case. And I think you guys can jot down this case. This one, Reed Jonathan. So in this case also, I think the facts here you guys can see lah. So basically, it's his application he wanted to admit to practice as an advocate and solicitor in Malaya, just to help out Najib case for one case only. Okay, so we call a special admissions. But unfortunately here, I think you have to try to think all our judges is very hardworking one. They will only allow our own Malaysian to do our case. They don't like to give other people to do their case. So in this case, they don't allow the application because they say in their view, they think just because you are Queen Counsel, because you know Queen Counsel is like is more like achievement lah. When people say you are Queen Counsel means that you are super good lawyer in UK. So then our High Court, they dismiss the application because they say that the Queen Counsel, although has a very high standard, they may know better than us, but they are not familiar with Malaysia law. So that's why they dismiss the case. They don't allow this Queen Counsel to practice in Malaysia. Now, to me, this novelty issue does not automatically redeem them complex justifying the need for the ad hoc admissions of Queen Counsel, as to do so will impliedly suggest that our local advocate and solicitor, including the appellate counsel and his team, are not known to the local law, non-flexible or malleable to the change on and development of the law, which means they are in the way to say that when we allow this foreigner to practice in Malaysia, then are we saying that our local lawyer is not good enough compared to UK law? So this case later I will share in the group. I think I share now in case I forgot later. So okay, so these questions, I think because it's 20 marks, I think as I always highlighted to students, if the question is only worth like 1 to 5, maybe your answer is like half a pages lah. 5 to 10, maybe like 1 page. And 20, I think you need to write more than 1 page lah. So in this question, I would suggest the structure will be like, you first need to advise there's how many type of admissions. So you need to write down lah, qualified person, special case, admission with special admission, and then foreign lawyer. Then you pick which one is more suitable. Then after that, you say the second type, the ad hoc, is the most suitable to our case. Then you raise a case about this Reed Jonathan to say, based on this case, it's not that easy for the foreign lawyer to practice in Malaysia. You must prove it only this foreign lawyer can do. But in this case, I don't think it's that case because judicial management, yes, we copy from Singapore, but it doesn't mean they will do better than us. Doesn't mean they know our local law better than us. So I think this will be your answer structure. Okay. So again, if you guys have any questions, just write in the chat box. I will look at it later. Yeah, I think someone asking the questions. Yeah, okay. So I think Ting Shok King, if I pronounce your name correctly. Yeah, you write the case correctly. Okay, so can we proceed to questions 2? Okay, Naidu was admitted as advocate and solicitor of the High Court of Malaya in 1990. After a brief practice as a partner of Mr. Singh and Rakan, he took on the positions of a general counsel in a large multinational company involved in oil and gas. Okay. In 2024, having served his contractual terms, Naidu wanted to return to legal practice and set up his own law firm under the name and style of the Chamber of Naidu. Okay. So he has inquiry at the Bar Council for the issuance of the practicing certificate and has been advised that he need to comply with the relevant provision of the Legal Profession Act. In applying for CGO supported by accountant report and other documents with regards to the professional indemnity insurance. Okay. Then, let me admit someone. Okay. Naidu classmate Bunga is a director of a foreign insurance company and has indicated to Naidu that she will come up with a special professional insurance scheme for him. Bunga is also a foreign lawyer who intends to practice on the part-time basis with Naidu. Naidu has been advised that there are new rules on advertisement by advocate and solicitor, and he is keen to put out an advertisement on his expertise in the field of oil and gas. Okay, advice 92. So number one, whether Naidu may decide to insure his practice on his own without subscribing to the professional indemnity insurance mandated by Bar Council. So I think one of the things you guys have to learn, right, is that try to understand what the question is asking. So basically, this question is asking, is it okay if Naidu decide to buy insurance without follow what insurance scheme provided by Bar Council? It's not asking you whether he can don't buy the insurance. No, the question says you must buy, but can I buy myself? For example, Bar Council provide insurance company A, but can I buy insurance company B? So this is what the question asking. Okay, I saw a question asking in chat box. So our thing asking, is the judicial management a new development in Malaysia after the Companies Act 2016 implementation? The question is whether Malaysia had this type of judicial management expert in this area, question mark. If I'm not mistaken, I think this corporate rescue mechanism include judicial management. It's not a new thing in Malaysia. Last time, I think in our old Companies Act also got, but maybe it's not that comprehensive. I think it getting more popular is after Companies Act 2016. This is what I understand. And I think the reason they wanted to put the question in that way is because, you see, our Companies Act is 2016. Now it's only 2025. So I think they are impliedly saying that this law in Malaysia is not that long compared to Singapore. So that's why they are questioning we may not have the expert in this area. Okay, so back to these questions. I think first of all, if you guys in the exam, right, you are not sure the answer, don't just leave it plain or don't give up. You know why? Because you may find answer in the statute. You know why? Because when you flick to the statute, right, you see, we just try to find the relevant section first. For example, for this, we will definitely is from the LPA, because LPA will tell you that we need to buy the what we call insurance. Then you look at the section. I think this is one of the tips I can share to you also. Whenever you study the statute, right, see the statute using the wording is like shall, S-H-A-L-L, or may, M-A-Y. So shall, I think everybody knows, right? Shall more like a mandatory in nature, means that you must do it, you must follow. But may is like giving a court a discretion. So the court may decide whether they want or they don't want, okay? So let me show you the screen first. I'm sharing the LPA. Let me know if you guys cannot see. So, like I said just now, when you answer the questions, right, law being law, law also written by human. So definitely they were written in somewhere one. They will let us know whether we need to do this and where says that. Remember, we are lawyer. So when you say something, when you say this is right, this is wrong, everything must be written. Either written by statute or decided by judge. Or sometime common sense. Okay. So like I said, just now the question asking whether PII can we buy for other insurance company. So the relevant section is this power to make law on professional indemnity. To be honest, I try to find any relevant case law to say that you must buy from Bar Council or not. I cannot find any case law. But what I know is that Bar Council do provide a thing called single master policy insurance. What does it mean? It means that the Bar Council will provide one, they will go on behalf of all lawyers, they will go and negotiate with one insurance company to say that, look, insurance company, now the entire lawyer committee, they want to buy insurance from you. Please give her a best price. Then every lawyer have to buy from this company. Then when you renew your license, your practicing certificate, you must upload this proof to say that you already bought the insurance with this insurance company. Then only Bar Council will proceed with your application to renew your practicing certificate. So, like I said, you refer to these sections, then they will say, Bar Council had the right to make rules and also ask all the lawyer to buy the insurance. So then you refer to this, then you say it's a single master policy. Okay, I cannot find the word single master policy in this statute, but based on case law and also you guys can Google, they will use this word single master policy. So by it means that there is only single master policy. There's only one insurance company. So to answer this question, I would say, yes, you are required and mandated by Bar Council to buy this same insurance company. Okay, so the answer should be section 78, capital A, to say that all lawyers should subscribe to the single master policy provided by Bar Council. Okay, and since it's just only 5 marks, like I say, half a pages will do lah. You just like write the section and explain a little bit. I'm sure you can get your 5 marks already lah. Okay. So same you guys, if you have you need any clarification, just write in the chat box. Okay, how about rule 4 of LPPLIR? What is LPPLIR? You type in the chat box, then I answer the next question first. Okay, question B, what is accountant report and for which account that such report must relate to? Okay, for here, I would like to tell you guys, when you run a company, a law firm, Bar Council make a rules that all law firm has 2 accounts. One is client's account, one is office account. So what is the difference between client's account and office account? Client's account, as the title suggests, you must only receive those client money. For example, stamp duty, purchase price. You must put all this client money into this client's account. And I think everyone also know, right? LPPER, if I'm not mistaken, or solicitor account rules says that when you receive this kind of money belongs to client, you must put in this client's account. And all your legal fee and your office disbursement, you can put in the office account. So there's 2 accounts. So this accountant report actually is important for those people who are running a firm, and the firm must ask the auditor to prepare the accountant report for client's account only, not office account. So why we need to do this accountant report is because Bar Council wanted to verify whether the advocate and solicitor complied with the solicitor accounts rule. How to say so? For example, today I received 100 ringgit. Bar Council and outsider wouldn't know this 100 ringgit is legal fee or stamp duty or purchase price. But you know, lawyer will issue invoice. So let's say I issue an invoice to say 100, then yeah, people will know they can tally 100 come in, issue invoice 100, so tally. So this is the law firm punya money. But if let's say you got one SMP, the SMP say the purchase price is 100 and you receive 100, then people know this money belongs to client. So when they audit, the auditor will ask you, this money is for what? Did you issue your invoice or not? If you didn't, then they know this money is belong to someone unless you issue your invoice. So when you issue an invoice, then it's a taxable income. You must pay the tax to government. So this is why they need this accountant report. So to answer the question, I think you guys can say just 5 marks. You say, again, we need to refer to the sections. The relevant section here will be section 79. Just a moment. Yep, 79. See, advocate and solicitor to deliver accountant report. So here again, you can say, according to section 79, we are required to deliver this accountant report, and it's for the purpose for the application for CGU annual, which means without the accountant report, the Bar Council wouldn't give you this CGU annual. Without the CGU annual, then you also cannot apply your practicing certificate. And the purpose is to verify whether advocate and solicitor comply with the solicitor accounts rule, and also to prevent the solicitor from misusing the client's money. I think this should be good enough for you to get your things ready. Okay, I think I saw already. Just now you say LPPLIR is Legal Professional Liability Insurance Rules, 1992. To be honest, I didn't know this. Okay, can you guys see?
Yes.
Hey,
Now it's
thank you for letting me know. Wait,
one of my friend is on at the waiting room. Can you help her?
Yes, I am meeting them. Thank you. Okay, so next one is C. So as I mentioned just now, they need to practice as a foreign lawyer in Malaysia. So when we refer to the foreign lawyer chapters, there are 3 types of foreign lawyer. Number 1 is international partnership. Number 2 is qualified foreign law firm, and the third one is foreign lawyer. I just briefly mentioned what are the differences. So basically, the first one is Malaysian law firm work together with foreign law firm. Okay. Number 2 is qualified foreign law firm, which is entirely is the foreign law firm, but then they practice in Malaysia. Okay. Then the third one is just a lawyer, which means just a lawyer come to Malaysia. Okay. So for foreign lawyer or international partnership or qualified foreign law firm, all 3 actually is the same. I mean, in the process of application, but just the different form you need to submit. Okay, so for example, if I'm applying for international partnership, then I need to submit Form A. If I'm applying for qualified law firm, I need to submit Form B. Foreign lawyer, then it's Form C. So these three, when you submit the form, you need to submit to the committee we call selection committee. And then the selection committee will, based on whatever requirements stated in this rule 6 of, the name very long. I don't know why all the legal profession rules super long. It's legal profession bracket licensing and international partnership and qualified foreign law firm and registration of foreign lawyer rules 2014. So it's like super long. So basically there will be listed down all the requirements you need to take into account. My suggestion is that you guys don't need to memorize everything because like again CLP is like super bulky. I think you just pick one or two factor to remember, memorize, then you just write in your answer. So to answer this question, so they're asking you whether we can admit or not, the answer is yes under foreign lawyer. Then you need to submit Form C to the selection committee and then those requirements stated in Rule 6. Okay? Okay, I will continue. Then what are the relevant rules regarding advertisement by advocate and solicitor on being specialized and on area of practice? So basically this question is asking you, is it okay and what are the rules I'm doing advertisement? Okay. I think the law you guys will know is publicity rules. So anyone, if you don't know, you may let me know. So basically in general, we are actually, I would say actually not allowed to do publicity unless you comply with Legal Profession Publicity Rules 2001. Okay, so under these rules, you are only allowed to advertise or write anything on social media with the approved information. So the approved information actually is defined in this rule. You guys can go and have a look. So in general, it's like approved information means your name, when you call, what areas of practice you do, how long your firm has been established, something like that. But Rule 4, sorry, that one is Rule 4. Rule 4 says that you need to follow their rules. But Rule 5 got like specifically mentions you cannot claim you are expert. So to answer this question, it's fine if you want to mention you are expert on oil and gas. For example, you're just telling people, oh, my firm mainly doing oil and gas. My firm doing criminal. That one is fine. But you cannot say the best defendant lawyer in town or what never lose a case lawyer. You cannot do those like title like so creative but you purely just telling people what you practice is fine, but don't over promote yourself. Okay, so then this will be the answer for your 5 marks. Okay, then can we continue to our question 3? Okay. Okay, so question 3. With the aid of decided cases, decide whether an advocate and solicitor may be held liable for negligence in the conduct of cases in court. And if so, whether the advocate and solicitor may, in facing such claim, set out the defense of immunity against the claim. Okay, so in short, the question is asking you, are we enjoying the immunity? Can we say the client cannot sue us for professional negligence? Okay, I think for 10 marks, like I say, should be like 1 pages So then you need to mention and explain a little bit of the historical things So I think I need to highlight to you guys why in UK the advocate is advocate only solicitor didn't enjoy the immunity Why advocate enjoy the immunity in UK is because you see, if I'm fighting a case with you, just because I lose a case, does it mean it's a negligence? So which means when you hire a lawyer, you want a sure win case. When you lose your case, then your client can sue you for negligence. So because of this, in UK last time, you cannot sue your advocate for negligence because they want to protect the advocate. But solicitor can be sued for negligence. Why? Because it's paperwork. So when you do the paperwork, you fail to do something or you write something wrong, then yes, it's a negligence. Okay. But in Malaysia, why we never enjoy this immunity is because in Malaysia, we did not separate advocate and solicitor. In UK, when you want to become a lawyer, you need to study BPTC, you become an advocate. You study another paper, I forgot called what already, it becomes solicitor. So it means that they are like different bar, Bar counsel, government advocate, another, I think, solicitor society, law society, government solicitor. But in Malaysia, we only have one, which is Malaysia Bar. So we are advocate and solicitor. You cannot separate, and you cannot also go and tell the court, oh, I'm commencing lawyer, oh, I'm litigation lawyer. So because of the differences, then you say I'm not liable, I cannot be sued for negligence. Yeah. So to answer this question, I think your structure, then you can tell lah. In Malaysia, we never enjoy the immunity. We are not the same like UK. It's because UK, they separate advocate and solicitor. In Malaysia, we are never enjoyed because we never separated. And then you also say, after 200 years, now UK also no longer enjoy the immunity already. I think the case is this Arthur Hall. So before Arthur Hall, barrister cannot be sued for negligence, but now they can sue for negligence already. So I think once you explain all this already, the historical thing, and then you can cite our famous case lah. Kopas Suram say this, Ling Sok Wah says we never enjoyed immunity. Then I think you cite some cases for this litigation matter. I think it's good enough for you to get your 10 marks already lah. Understand? Cool, cool. Okay, if no question, I will proceed lah. Okay, I saw the questions are just a quick question in terms of admission. For my understanding, the articles clerkship is another method of admission as well. Am I right to say this? Sorry to bother. Okay, no worry. Okay, this article things article clerk I think my understanding is those days we don't have enough lawyer. So instead of asking everybody go and study law, and then I think that time also not cheap lah. So then they like open for those qualified, I think it's a clerk lah. That's why they use the word clerk. Because you know those clerk maybe do work better than lawyer because they just don't have the qualifications so that's why they open for those clerk who are experienced also become a lawyer. But nowadays why you never see and you never see in the exam also, I think it's because of that time that era we don't have enough people but nowadays like you can study CLP, you can study PPTC, so no longer applicable in our era already but you are right just another type of admissions but I don't think it's applicable for now already okay. Then next one, an advocate and solicitor has certain duty towards his client. Discuss. Okay. Yeah, I think you are right. It has been, I don't know whether approached by any law or not but I know it's no longer applicable already Okay. So whether advocate and solicitor has certain duty towards his client or not. The answer, I think you can look from different aspects. Number one is that the duty toward your client is whether you can accept these cases or not. I think you can discuss the chapter is like acceptance of brief. Why? For example, my client approached me, but actually I represent another client already. That client actually wanted to sue him. Let's say I represent A, and then B approached me to say, hey, I got one case, A trying to sue me. So my duty to this client is that I need to tell him, if you look for me, they may have a conflict of interest. I may utilize your information, your confidential information. So this is the first thing that I think you can think of from that chapter acceptance of brief. Number two, wrongdoing. You see, when your client, yes, we wanted to fight for the best interest for our client, but it doesn't mean your client want to do anything also you must support. You must let your clients know what is legal, what is illegal. I think this one, maybe I can highlight a little bit of the evidence. You see, yes, the conversation between client and lawyer is protected, is privileged. But it doesn't mean your client say anything also is protected. I give you a scenario. If your client murder someone, they approach you to say, hey, Reno, I think I commit an offense. Can you help me? Okay, the story is like this. So yes, the conversation is protected. I cannot go and backstab him and tell the court, hey, my client actually killed people. That one is unfair to my client. But if let's say before my client commit any offense, he come and approach me, he say, hey, Reno, can you teach me? I wanted to kill my wife. Can you advise me how not be sued or find out by some prosecutor? That one is not protected by privilege. So there's a difference between, the duty, your client. Yes, your client is your paymaster, but it doesn't mean you need to assist your client to do any illegal things. So here, one of the duty you do towards your client, you must remember also, you also is an officer to the court. You cannot do this wrongdoing thing with your client. And the third one, I think, is the conduct. You cannot suppress the evidence. For example, okay, not to say suppress most of the time, right? let's say if you guys have any experience buying a property with a developer, right? They will always tell you free legal fee. Actually, the free legal fee is not entirely correct. It's because technically they are not your lawyer. They are developer lawyer. So in that case, when the purchaser wanted to buy a property from a developer, that lawyer will attend signing with the purchasers. That lawyer need to specifically explain to the purchasers that I am not your lawyer. In the event there is any dispute, I'm just attempting and explain the terms and conditions to you only, but I'm not your lawyer. So bar counsel ruling and these sections, we got specifically mentioned this lawyer need to get the consent or inform the purchasers that I'm not your lawyer. Otherwise, there's a conflict also. So this is one of the things that the lawyer has the duty towards the client also. Understand? Okay. Let me see. There's some student joining too. Okay. Next one. Usually all these kind of questions you see when they mention a lot of facts when they're talking you can just skip it one because most of the time I can assure you nothing to do with the questions one. So you can straight away jump to here. So basically here straight away ask you, discuss the essential and importance of the professional ethic and that regulate the legal profession under the LPA. So it means what? Explain why so important we need to have this ethic. Just asking you why we need to study this ethics subject Okay, I think one of the things I can remember when I was doing my privilege, when you guys doing your privilege, then you need to join some activity with help by the bar council or your state bar. They will keep telling you why you need to have your ethic, why you need to keep your professional. So one of the things I remember until today is that, so they give you a scenario. Let's say today, I as a lawyer, I did something wrong. So they say next day the newspaper they won't write Reno do something wrong. They will write a young lawyer do something wrong. So in other words, they are saying that when you carry this lawyer capacities, you are not only represent yourself. It's not your personal capacity. You also represent your whole committee, your all your legal friend, bar counsel. So which means whatever you do, people will zoom in and say lawyer do what, lawyer do wrong, lawyer makan money. That's why the people always make fun to say bulut lawyer, lawyer bulut. So that's why the importance of ethics is that we wanted to govern all our lawyer friends don't make any mistake because whatever you do may impact our image. So I think to answer this question, 20 bucks, I think what you can do is that you say, you may refer to LPPER, Legal Profession, Practice and Etiquette Rule. So in that LPPER, most of the rules is talking about how we manage uphold our dignity, how we talk to our judges, how we are not supposed to take our client interest. I think you can call related to many chapters. I think you can start from how you accept the case. If there's a conflict, you shouldn't take. If let's say the defendant is your brother, sister, or your sibling may affect your independence, you shouldn't take. And next chapter, conduct of the proceeding. So let's say you don't have sufficient time to take out the case, so you better don't take. You cannot lie to the court. You must always cite the correct case and proposition of law to the judge. You cannot fight with the judge also. This is the second chapter. And the third chapter, I think, is like performance, general conduct. I think you cannot have dual professional. You cannot be a accountant and also a lawyer at the same time. So all this chapter you can correlate to says that why so important is because we wanted to maintain our profession, our indemnity, and accountability. Why? Because you see, without the LPPER, everybody also publicize. Everybody also say he's a profession. Everybody may take contingency fee. So it will lower our image. So we wanted to know what can we do when the lawyer do wrong and whether there's any written rules to say that lawyer shouldn't do what, lawyer should do what. So all this is to maintain the public confidence of the entire lawyer. You see, if the people also think the lawyer is not profession, how can you ask the people to trust lawyer can represent me? The lawyer know the law better, right? Okay. Why a lawyer can be a company secretary? Good questions. I think my friend also doing company secretary. I stand to be corrected. I'm not sure, but I think company secretary maybe not consider a profession, I think. Why? Because you see, the lawyer can also be a commissioner for oath, you know, those like Persuruhan Jaya, Sumpah. It doesn't conflict our capacity. I think maybe also correlated, I think. But accountant and lawyer, I think maybe you can like, it's a different field. Then and they are the profession, they got one body to govern. You cannot like, I'm a lawyer, I subscribe to Malaysia Bar, then I also accountant, then I subscribe to another association. I think this is why they don't allow. But I think company secretary, they don't have the association like us. But I stand to be corrected. Okay. They are being member of MECPA. I don't know what is MECPA. Okay. So can we continue to our land? I think I heard Dr. Chi says you guys done your land already, but I will just quickly go through with you guys. Okay. So Bija has just completed his study and is looking for a business opportunity. Bija has a friend, Tugu, who is a building contractor. Bija owns a big piece of land. Okay. Bija and Tugu decided to build houses on Bija land. Bija subdivided his land into 5 individual titles and Tugu built 5 units of single-story residential house on it. Okay, see, this is the keyword they are telling you. 5 houses, residential purpose. What? HDA. Because just sharing, I think, I don't know if you guys know or don't know, when you build a house more than 5 units, regardless whether partially for residential and partially for commercial or not, you will be governed by Housing Development Act. So which means the contract, you must follow this HDA punya standard SMP. You cannot simply say, I'm developer, this is my house, you want to buy, you buy, you don't want to buy, you go away. Cannot. As long as you are building 5 houses above, and then you are for residential purpose, even partially, you are governed by the HDA. Okay. So Bija appointed his counsel Halim as his lawyer, and all purchaser of the 5 unit of the house signed the SMP prepared by Halim. According to the terms of the SMP, the house will be completed and vacant possession will be delivered in 30 months from the date of the SMP. Okay, here is a hint to tell you they don't follow the standard Schedule G. Okay, because the individual title, so it's a Schedule G. So I think I can highlight the case to you guys is Lipochu. Lipochu says that if you don't want to follow HDA, it's fine, but you must provide better terms. So follow the Schedule G, it should be 24 months. So you use 30 months is the worst. It's not a better term, so cannot. So the SMP was silent on the issue of any delay in the completion and delivery of the vacant possession of the houses. This also cannot. How can you silent? Because pursuant to the Schedule G, there is a standard timeline and template to say that what happened if you fail to deliver. Okay. Then Tungu delay in the construction of the houses and deliver vacant possession of the houses to purchaser 36 months after SMP. Okay, again, 30 months already cannot accept really. How can you accept 36 months? Okay. Then what fine? All purchasers of the house were unhappy and demanded Bija to pay them the compensation for the late delivery of the vacant possessions. However, Bija and Dugu points out that they need not pay any compensation to any purchaser for the following reason. Number one, they are not bound by the HDA as they are not the developer. Okay, this one I think you guys can also refer to HDA to say that the definition of developer need not necessarily be a company. Developer can be individual, can be company. So I think this one you can go and rebut to say that you are not right because developer can be individual. And as long as you build 5 houses above, and for residential purpose, you are bound by it. Since they are not developer, they are not bound to adopt Schedule G. So this one also wrong, as we discussed above. They do not need to pay compensation. This one also wrong, because for follow Schedule G, there is a standard liquidated ascertained damages. When you fail to deliver the house within the stipulated time, you are required to pay the compensation, the LED. Okay, so purchaser had opt out when they signed the SMP. This is also not correct. Why? Because I think there's one of the key states that HDA is a social contract to protect the home buyer. So you cannot use your freedom of contract to choose to contract out of the legislation. The law should be bigger than contract. For example, law says you cannot sell drug. Then you cannot say, hey, freedom buyer, freedom seller, he willing to buy, willing to sell, why cannot? Cannot. The law says cannot, then it's cannot. Okay, so it's a white contract. Okay, but I think I can highlight one case to you guys is that although they use the wrong form, but it doesn't mean the entire contract is invalid. The contract is still valid. The case is this Audrey. When you use the wrong schedule or you use the wrong form, it doesn't mean the entire contract is wrong. The S&P is still valid. Okay? So although they don't use the correct S&P, but they are still bound by it and should follow for 24 months schedule G. Okay? And let me continue. Do let us know if I explain too fast. Then next one. Ali owns a piece of land in Medaka, Pahang, and has later a double-story house on it. Okay, I saw a question. It says, can you explain section 22D of the HDA regarding assignment? Good question. Come. I think many people, they don't understand why we need this so-called assignment, I try my best to explain because it's really a bit difficult to understand. So basically, it's like this. You see, Malaysia, we practice torrent system. What does it mean, torrent system? Torrent system means like we must register, which means when I sell you, when you buy, you must go to the government department to register to say that this house belongs to me. This is the proper torrent system, what it says. But in Malaysia, we have one very funny nature is that I buy the house, I sign the S&P, but the land office had yet to issue the title. So jadi, even I wanted to register my name also, there is no title for me to register. But you see, the developer need 24 months or 36 months to complete. Can you assure all purchasers are also able to hold the house for 24 months or 36 months? What if boyfriend, girlfriend buy house, break out? What if the purchaser pass away in the halfway? What if not able to pay the loan, so they want to sell? So in that case, they come up with a new idea is that instead of saying I sell my land, I say I assign my land, which means I use my equitable right, I assign to people, I give to people. So the difference is, with title, we call sale and purchase, buy and sell, transfer. But without title, we call assignment, deed of assignment. I give my right to you. I didn't sell to you, I just give my right to you. So in the event when the title out, we can tell the developer, this is the real owner. The real owner can register his name because I assign my right to him with it. So this is the so-called assignment. So why this assignment becomes so complicated is because like this. Imagine today I'm the developer. I sell my house to A, to B, to C. So by right, when the title out, I will register my name to, from Reno, transfer as a developer, transfer to A, transfer to B, transfer to C. This is the perfect situation. But if let's say in the halfway, A say I wanted to sell to my girlfriend. So A need to inform me, because if A don't inform me, I don't have record. I only have S&P between me and A. So when title out, I will like gila, blur, blur, I transfer to A. Then the girlfriend come and sue me to say, Reno, why you didn't transfer to me? Then I will tell the girlfriend, how would I know A sell to you or transfer to you? So that's why the law says that if you want to assign, so understand, assign, now it's not sell, because don't have title, they assign. If A wanted to assign to girlfriend, they must serve a notice to Reno to inform Reno that, Reno, look, now I want to assign to my girlfriend. When title out, transfer to my girlfriend. Yes, this is assignment. But now the question is that, I as a developer, I feel, hey, you give me a lot of work. By right, I just need to keep your record, the S&P. When title out, I transfer to you. That's it. So I feel unfair. I say, you make me more work. So I want to impose a so-called administrative fee. I say, you give me a lot of work. So that's why those days, when without HDA land, the developer say, you can assign, no problem one. I charge percentage. I charge you 1% of your selling price. So now HDA come in, they say, to do this assignment, you only need to inform, don't need to get consent. That's why here, consent is not required. You just need to inform. Once you inform, the developer can only charge you 50 ringgit for administrative fee. Why? Because last time I just keep S&P, but now I need to keep S&P and also the assignment between A and the girlfriend. So this is why administrative fee gets so complicated and mafan. But for those situations when you are not governed by HDA, for example, the what we call commercial title, then not governed by HDA, we also got case law to protect. So case law say, yes, developer, I know you are not governed by HDA, it's fine, but you don't charge so much, you charge 500. So this case say commercial property only charge 500. Okay, but for commercial, whether you need consent or not, to be honest, I have some dispute with my student. My student say, Mr. Tan from BSc says don't need consent, can assign. But my view is that I think need consent because Section 4 CLA only say you can assign, but doesn't say you don't need consent. I personally think still need consent. And in my practice, to be honest, I think they will always still ask for consent one. But this is my view lah. So you guys can let me know if you have other opinion or any case law to support lah. Okay? Okay? A, your name is A, I don't know your full name. So I hope you understand what I explained. Okay, good. So Ali owned a piece of land in Mataka Bahan. So it's a double-story house. Ali also owned a motor workshop business known as Motor Repair Ali Senai Berhad. He runs motor workshop business in the backyard of his house. Ali took out a loan from XYZ Bank in 2014. As a security for the loan, Ali created legal charge over his land in favor of XYZ Bank. Understand? The original title was kept by in XYZ Bank custody. I just quickly explain. So basically in Malaysia, what is the difference between mortgage and charge? My understanding, again, I stand to be corrected. Mortgage means when you borrow money from the bank, the property will register in the bank name first. Until you pay off, only the bank will transfer back to your name, will register your name. This is mortgage. But charge means the title itself will mention my name as the owner and also mention that I owe money to certain bank. So when, let's say, a buyer wanted to buy my house, the buyer will check, do a land search and check my title or reno other hutang money to bank. So the purchaser know they need to pay off the debt to reno bank first. Then only reno punya bank will return the original title. So here, it's normal when you borrow the bank money, the original title will kept by the bank. Why? Because they also worry you go and sell the land. So the original title will kept by the bank. So Ali needed some additional fund to extend his motor workshop business further. He decided to refinance his land. He approached Banyak Bank and a loan sum of 350,000 was duly approached by Banyak Bank. The loan agreement and charge document in the form of Form 16A of the NLC were duly signed by both Banyak Bank and Ali. Banyak Bank solicitor obtained a redemption statement from XYZ Bank stating that a total sum of 200,000 was due and payable by Ali to XYZ Bank in order for Ali to redeem the sale land for XYZ. Okay, I think some people may not understand what is redemptions are. So basically, seller, buyer, seller got his bank. By right, if no bank, just seller and buyer, buyer pay money to seller, close file. But most of the time, seller will own money to his bank. Your last time, seller buy house also borrow money. So the buyer need to make sure he settle the vendor punya bank. So this process we call redemption. Redemption means like buying back. I buy back the vendor punya portions. So I pay you the redemptions already. So I will ask vendor bank, how much vendor own you? So the vendor, the seller will say, okay, 100. So and when I pay, when the purchaser pay, then the vendor bank will only return the original to him, the vendor. Then only the vendor will transfer back to purchasers. So this is called redemptions. Okay. Then, okay, Banyak Bank lodged a private caveat on the land on 20th January 2023. I think one of the tips also always take note when they tell you the time sure got something one. Okay. Thereafter, a sum of 200,000 from the total approved loan sum of 350,000 was released by Banyak Bank to XYZ Bank as full payment of the redemption sum for the sale land. So basically, it says that I borrow money 350,000, but then I still own 200,000. So I need to pay 200,000 first. Understand? Right? Yeah, redemption sum. Okay. Upon receipt of the redemption sum, XYZ Bank, which is the first bank, duly released the original documents of title which were within its custody to Banyak Bank solicitor. Okay. Then, however, a fire took place in the Banyak Bank solicitor office and the original documents of title has been perished in the fire. Banyak Bank has requested Ali to make an application for the issuance of the new documents of title replacing the old documents of title which has been perished in the fire. Ali submitted an application for issuance of new documents of title on 1st March 2023. So you see, in between, release money on January, apply new title on March, and the land office notifying that it will take approximately 6 months. Okay. On September, which is in between January, March, and September, Ali collected the new title and forwarded to Banyak Bank. Okay. However, both Ali and Banyak Bank noticed that there was another private caveat entered on the same land on July. So which means, because if not because of the fire, you lost the original title, you could have already registered your name. But because January release money, March apply new title, before September, in July, in between July, someone entered the caveat. Okay. I think they're telling you the timeline. I think they want you to compare who got the better right. Okay. So by Kasim. Kasim is Ali business partner and had given Ali a sum of 150,000 or Ali promised to transfer part of Ali share in the workshop business auto repair Ali Sanya Berhad to Kasim. So basically it's a money dispute I owe you money or some money dispute, then I enter caveat So Banyak Bank is upset because the new registration of illegal charge on the sea land is now restricted by the private caveat by Kasim. Okay. I assume you guys read the question one time before, so I read quite fast. So A, both Banyak Bank and Kasim have claim over Ali's. Whose claim should take priority? So again, need to mention 6 months, don't need to mention that. But I just briefly tell you torrent system registration is everything. By right, who register, who has the indivisible title. So like our Mr. Tang from BSC says is Superman So when I register my name, I'm Superman. Nobody can challenge me. Unless section 340 sub 2, fraud misread until forgery those only can affect my right So but here, Banyak Bank only release money but never register. Okay, and then Kasim just have a private caveat, also never register. Both only have equitable right. Please remember, I think legal and equitable is like this. Legal means like when you register your name, then it's legal right Equitable means like you didn't register, but somehow because your effort or you do something, you also have certain right, like the bank. The bank release money You cannot say just because the bank release money but never register his right is not recognized by the law cannot So that's why the bank only have equitable charge or unregistered charge. So now is unregistered charge versus monetary claim. Which one is prevail? Both also is money. Yes, I agree. But which one take prevail? Okay. I think we do have cases to say that let me see yeah, okay. I think you guys can use this case. Standard Chartered Bank versus Yak Sing Yong. Judgment creditor does not take priority over the unregistered charge. Okay. Kasim here, he is not a judgment creditor. Judgment creditor means like I win a case. I win a case. So you owe me a judgment. So I'm judgment creditor. So in this case, even you win a case, doesn't mean your right will prevail a bank who fail to register the charge. So compared to these questions, Kasim got nothing. Kasim only got private caveat. Private caveat will never take priority over a charge. So this is the case law says that. So in other words, even though Kasim today go and sue Ali and win the judgment, Kasim also don't take priority over the bank, even the bank didn't register. Not to mention in this case, Kasim don't even have a judgment. So I think by applying this case and also explain what I say, it should be good enough to say that Banyak Bank is take priority. Okay, 6 mark, half a page. I think you guys all know, right? The structure should be introductions, law, facts, your opinion. I just quickly show one time. Like the question require us to compare whether Banyak and Kasim have claim over Ali land, who has the claim, whose claim take priority. So this is the introductions. Then you say, follow the law, torrent system, Malaysia practice torrent system, registration is everything. However, on the facts, both Banyak Bank and Kasim has not registered their right. And based on the facts, so now we're talking about facts, Banyak Bank only have unregistered charge. And based on the facts, Kasim only have a monetary claim against Ali. Then only you say again the law, which is the what I said the case just now Standard Chartered says that unregistered charge should take priority. Then only you write your conclusion. I think like that only is a perfect answer. So when the examiner read, he can understand what you're trying to say. And also please try not to write everything in one paragraph. The people, old man like me, we don't like everything squeezed together. So try to write paragraph to paragraph. One, I think short, 3-4 paragraph for one paragraph. 3-4 lines for one paragraph. Okay. Then, what steps should be taken by banyak bank to enable to register illegal charge on the land? Okay, which means what should he do to register? Okay, so if you want to register, you just go to land office lah. But the problem now is there's a private caveat. So what is the effect of private caveat? Prohibit any dealing. You know, last time when I was student, I cannot understand what does it mean, prohibit any dealing. But I think you can just understand in the layman terms, like prohibiting dealing means like stop any transaction, stop transactions. But you see, when I say stop transactions, it's like so layman. But when I say prohibit dealing, it's like more atas. So prohibit dealing or transaction, it means that because there is a private caveat lodged by Kasim, so the banyak bank want to register also cannot because stopping all the transactions. So what they need to do is that, number one, remove the caveat first. Then only you can register because it's just 7 marks. If today is like 10 or 20 marks, maybe I expecting some cases to add on. But since the question is said, what are the steps? So what you need to do, number one, remove the caveat. So to remove the caveat, there's 4 ways. Number one, 325. The caveator, which is Kasim withdraw by himself. Impossible one. Number two, 362, 326. Removed by the registered proprietor or interest, which is proprietor means the owner. Here is Ali. Interest means anything with interest. Either you are easement right or either you are bank right or something like that. But remember the keyword, register. You must register first, then only you say you are registered interest. But in this case, because the bank never registered, so he is not registered interest. He only got interest. So cannot apply 326. So remember, 327 can apply by aggrieved person. So what are the difference between 326 and 327 is that 326 is only for person who register the name, either owner or bank or line as long as your name is registered there. But since on the fact the banyak bank never registered the name, so we cannot apply. On the other hand, 327 is for those people not happy, aggrieved person, not happy. So as long as you are the aggrieved person, you show interest, then you can apply for these sections already. So how? Once the banyak bank apply 327 already, the caveator need to show the court, which is Kasim. Kasim need to show Kasim has caveatable interest. Kasim need to show there's a serious question. Kasim need to show there's a balance of convenience. So let me show you. Kasim enter caveat, bank want to remove. Kasim will tell the court, hey, my interest caveatable, protected, serious issue, don't challenge me, I must have a right to be heard, something like that. So if Kasim cannot show, then bye-bye. The caveat will be removed. Okay, number 4th method is after 6 years, but I don't think we need to wait until 6 years. So I think after you advise 327 already, then can remove, then advise the bank register accordingly. 7 marks. Easy, right? Again, introduction, law, facts, opinion. Okay. Then third one. In your opinion, does Kasim has a caveatable interest in the land? I believe all of you guys should know, right? What is caveatable interest? Pursuant to section 323 sub 1 sub A, caveatable interest means claiming title, claiming registerable interest, claiming rightful title. What does it mean? Claiming title means like, I want my title. I have some right, some sort of right in the title. Let's say I'm the son of the landowner, or I wanted to buy this house, okay? Or claiming registerable interest. Registerable, you see, ABLE means can or cannot. Let's say a potential buyer, okay? And right to title means I have some sort of right in this title. For example, I'm the co-owner. But we have cases to say that co-owner himself cannot lodge caveat on his own land, but got some exceptions. I think there's some cases. Okay. So in this case, I think Kasim just want the money, so he doesn't have the caveatable interest. And you can cite the case law, I think this one. Monetary loss is not a caveatable interest. Okay. Okay, let me continue. Then, Musang is the registered owner of the agriculture land. He took out a loan from Taman Bank for 300,000 with a monthly interest rate of 3% per annum. Okay, I saw the questions. Oh no, there's no question, sorry. I saw wrongly. Okay. As security for the loan, Busan created a first-party legal charge in favor of Taman Bank. So let me just quickly explain what is first party and third party lah. First party means A buy house, A borrow money. This is called first party legal charge. But if let's say A buy house, A punya parents borrow money, so that one is third party. Okay, which means those people buying her house must be the person who borrow money as well. That one is first party. But if let's say husband and wife buy the house, but only husband borrow money, although husband name appear in S&P and also the loan, but it's still called third party. It's because different name. The so-called first party must be like exactly the same. How many people here in S&P also must be how many people in the loan agreement. Slightly different, you become the third party already. Okay, so after a few years, Musan started defaulting on his monthly installment. Okay, Taman Bank sent Musan a letter requesting him to make prompt payment of his outstanding installment within 7 days from the date of the letter. Okay, again, this question is about like order for sale, cause to the contrary, right? I also quickly explain what is cause to the contrary. So whenever you wanted to oppose a bank along your house, right, what you need to show is cause to the contrary, short form CTTC. Lao Li Lian, the case. So can the bank ask you to repay the whole sum within 7 days? I think the answer clearly is no lah. Always remember, we are democracy country. We will give more day. The law is protect, give people chance. So it's 1 month. Okay. So the law is at least 1 month, unless the contract say otherwise. Section 3254 of the NLC. So remember, when you default payment, the bank cannot ask you to repay within 7 days or immediately. Must at least give you 1 month, or unless the contract say otherwise. Okay. So this is the first cause to the contrary lah. So Musan ignored the letter. After a duration of 6 months, Musan received a notice from Taman Bank notifying him that an order for sale of his agriculture land has been obtained at the High Court, and the agriculture land will be auctioned off in 1 month time. Okay, and then so far here still okay lah. Just say will be long lah. Okay. Together with the order for sale, the bank had attached copy of the application of summons for an order for sale. Musan was very angry as he was neither notified of the hearing date for the application and not given a chance to appear in court during the hearing of the order for sale application. Okay, here we have another problem already. I think common sense lah. I mean, when you want to sue somebody, you must notify them. So here certainly there's a law lah. So when you fail to notify the borrower, right, it certainly is a cause to the contrary under condition precedent. I think the case you can use is this Pervilla Harbin Bank. So Pervilla Harbin Bank says that if you wanted to lend on people's house, you must strictly follow the procedural requirement in Order 83. And here, I think the most important one is, here is affidavit. I think, you should use this Belaya Banking Bank. The chargee is the bank has the duty to serve the notice of hearing of the summons as well as the notice of any urgent hearing of the summons on the charger. So in this case, it clearly says that you must inform lah. But actually, the Order 83 also mentioned you must inform lah. If I'm not mistaken, it's like 4 clear days you must inform the charger. Okay, so this is the second cause to the contrary. And then Musan also noticed that Taman Bank has charged him a penalty interest of further 5% of non-payment of the loan. The term was not stated in his loan agreement. I think this timeline to pay lah, never serve notice lah, and also the interest always come out in the order for sale chapters lah. So the interest one is one of the cause to the contrary under indivisibility. Okay, so I think you can use the case here, whatever case. I sure got some case lah. I hear my notes. I got three cases lah. You just choose the most simple case to memorize lah. Okay. Okay. I mean, I think we can understand also lah. Interest you cannot simply charge one lah. Okay. Yeah, I think that's about it for these questions lah. Then B, what is prohibitory order? Okay, I just quickly explain what is prohibitory order lah. As the title suggests, prohibitory means like prohibit lah. I'm stopping you, preventing you lah. But the prohibitory order here refer to when I get the judgment ready, I worry you will quickly sell your land to avoid your legal liability. So I apply prohibitory order to stop you selling your property. So this is prohibitory order. Okay, I think this one also they mentioned in the caveat chapter. Yeah, prohibitory order. 334. A judgment creditor, which is the person who win the case already, can apply for PO to prevent the judgment debtor from dealing with his land so as to enable the judgment creditor to apply for order for sale. So which means you win the case, doesn't mean you can let along the house automatically. You need to apply judgment. But in the meantime, people not stupid. When you are applying order for sale, people can quickly sell. So you need to apply prohibitory order first, stopping him from selling the house. Okay? So this is for our land. Do you guys need me to do last question for probate? Or you guys super king already, then I don't go through already. You guys need? Yes, please. Okay. So, Taylor, accomplished architect, died recently, leaving behind her son, Ziggy, and the daughter, Jolene, and his beloved wife, Teresa. So, Taylor is believed to have died in estate. In estate means the other view, no view. Despite having amassed untold wealthy during his lifetime, it is estimated that the estate is worth more than 55 million. Okay. Having consulted a legal clerk, Teresa wishes to apply for a letter of representation. Okay, just sharing. Letter of representation means probate and also LA. Means like when you are not sure it's probate or LA, you will just call letter of representation. But when you're sure there's a will, then we will call grant of probate. When you're sure there's no will, then we call LA, letter of administration. Okay, seeking to administer the estate of Taylor. Ziggy has now discovered that Teresa had entered Taylor bank account and refused to account for the whereabouts of the cash. Ziggy believed that Teresa has been spending the money on holiday approach with and buying expensive car and gift for and her newfound boyfriend, Bogo. Jolene, on the other hand, was approached by Bern, an old friend of Taylor, who informed Jolene that Taylor has executed a will, which he witnessed together with another friend, Rubas. Bern had also indicated that the only beneficiaries stated in the will are Ziggy and Jolene, and the will is kept by Mutu, a semi-retired lawyer based in Penang. Ziggy has since obtained a copy of the will. When confronted the will, Teresa decried and that the will was a forgery and that she will apply for the letter of administration immediately. Okay? So what step could they take to protect their interest in the Taylor estate, i.e. against the issuance of the letter of representation, and what is the procedure for that step? So not only land law we have caveat lah. So in probate also we got a caveat law. So as the same in land law, caveat in land law is like prohibiting the dealing. So the caveat in probate means like stopping the issuance of grant of probate of LA lah. So the question basically asking you what steps should you take. So you should advise your client to file a caveat on the estate so that the court won't grant any LA or probate to any person. I'm just sharing so when you guys next time become a lawyer, right? When you do probate or LA, when you file all the necessary applications you did the court system can check whether this person estate applied by any relative or not. If the system shows that someone already applied the LA or probate before, your application won't be allowed one. So this is the probate So when you apply, it will appear there already. Okay. Then what is renunciation and whether Teresa may secure a letter representation without securing Ziggy and Jolene renunciation. In layman terms, renunciation basically means like give up. I don't want. So the question is asking what is renunciation? So you can use the layman terms means like giving out or waiving their right. So whether Teresa, next question, whether Teresa may secure the LA or probate without getting Ziggy and Jolene renunciation. The answer is no. Why? You see, Teresa is saying that there's no will. So when you no will, we will follow distribution act. Distribution will give the money or estate goes to, if you got parents, go to your parents. If you got spouse, go to your spouse. If you got children, you go to your children. If all other will share by them. But the kids will take bigger portions. If I'm not mistaken, I think 2/3. And then parents and spouse get 1/3. So in this case, if you are saying there's no will, right, then by right, Ziggy and Jolene also are the beneficiary. So how can you apply without getting their consent? So yes, the answer is yes, you must get their consent. Or unless they renounce, they say they don't want. So you need to answer like that. Okay, last one. What is meant by propounding a view, and what is the procedure involving in impounding a view? What are the grounds that barrister may use to challenge the validity of the view? So you see, this question again also asking two parts. Number one, what is propounding? Propounding means like, I think you can answer to prove the view, to prove a view. And what is the step involving in proving the view? Okay, to prove a view, you can apply its citations, which means, let's say, for example, today someone says that I got my daddy view, so I don't believe them. So what you can do is you apply citations. I think many of you may not understand what is citation. So basically, citation, you can just understand like, I'm citing you, I want to challenge you. Challenge you what? Challenge you, citation got three types. Number one, to accept or refuse the grant. For example, my daddy, we got 4 siblings. My daddy say, ask my elder brother to become the executor. But my brother doesn't want to do it or lazy to deal with it. Always say busy. Then I will do the citation and ask them, brother, do you want to do or not? Do you want to do, give out. Okay. Second situation, my brother want to do, but do very slow. Then I say, do within 6 months. Do within how long? This is second type. To take up the grant. Ask them to take out the grant. And third one, let's say my brother say, this is their view, but I don't trust. I say, prove it is their punya view. So what you need to propound the view is to do citations. So you need to ask them to do the citations. And what are the grounds can challenge is say so they fail to comply with the, to prove the view, you need to challenge the deceased does not have testamentary capacity, which is the capacity to do the view. Number two, never comply with Wills Act. Let's say there is no two lack of the witness because pursuant to Wills Act, you must have at least 2 witnesses and there is suspicious circumstances. I think 10 marks, you don't need to write so details. You just need to briefly mention will do. Okay? Cool. Everybody understand? Good. I like everybody say understand, then very good. So then we will stop here. I think I got another pro bono class in, I forgot when already but it's for the general paper then we will continue in next class . Yeah, I saw another questions. So can you explain the case of Setiako Engineering versus Mak Yan Tai in relation to CMP versus M-Bank? Am I right in thinking that Setiako basically narrow the scope of protections of 340 sub 2, since Setiako, if origin of the title was seen in Setiako, if the origin of the title was void due to fraud, you are not considered a subsequent purchaser? Sorry, I don't know Setiako case, but I know CMB and M-Bank case. Never mind, this one also I jot down. Let me take a look, study, then I get back to you. Setiako versus what? Setiako Engineering. Okay. I will take a look. So I will check 2 things. Number one is the legal profession liability insurance rules. Another one is this Setiako. Let me check it, then I update in the group. Okay, so that's it. Partial tenancy and partial what? Intestacy. Partial tenancy and partial intestacy means like do the will partially, is it? Okay, another question is it possible you explain on the immediate purchaser and subsequent purchaser? Okay, the partial intestacy I come back to you later. Okay, immediate and subsequent purchaser is like this. You see, when we wanted to say that I am the registered owner, I'm protected by indivisibility, means like I register already, my name will be protected by the law. Okay. But the question now is, we may have some situation not that simple. For example, register my name protected, simple. Second situation, register my name, but somebody forged my signature. Let's say A . So in that case, A punya title will be set aside under section 340 sub 2. Okay. But what if, more complicated, A immediately go and sell to B? The question now is, the law should protect Reno or should protect B? So right now we got 3 people. Reno kena tipu by A sell to B. Okay. So B will be the so-called subsequent purchaser. Subsequent after that. So what is immediate purchaser? Immediate purchaser is like here, immediate. A is the real owner, but someone imposted to say, I am the A, but actually he is not A, sell to B. So in this case, it's only A and B. The law doesn't protect B. Why? Because if you study here, 340 sub 3, where the title or interest of any person or body is divisible by any reason specified in 340 sub 2, which is fraud, forgery, it shall be set aside. Okay, that one is good enough lah. When Renault is registered owner, someone tipu Renault, the title can be set aside. That one easy. But the question now is like proviso, provided means like no. Subsequent purchaser is bona fide purchaser for valuable consideration. Means when Renault kena tipu by B, B sell to C, C is an innocent party, man. So the C is as an innocent party doesn't know the story between Renault and A and B. So the law will protect them because C also make money already. So he also is innocent. So the law will protect him. But why doesn't protect immediate purchaser? My understanding is like that. If today I deal with some owner, I'm supposed to check the owner background. I can check the owner background. So I should caveat emptor, the Latin called caveat emptor. I need to check. I need to do the background search. But if C cannot check previous, cannot check until Renault. B can only deal with B. B can only deal with A. So he can only see whether A is the owner or not. That's it. But if the fraudulent deal with me, straight away, he should know whether I'm fraud or not. So the law only protect the third party. But if you guys think it's too complicated, you just remember must involve A, B, C. The C only protect by this proviso. Okay. Okay. So we come back to the partial testacy and partial intestacy. I don't know why you ask this because my understanding is that it's either got will or no will only. But I can only know relate when you have a will, but then the executor doesn't willing to act, or the executor die before the testator. Then we don't call partial intestacy. I think that one we call will LA with will and next. You see, if we have will, we call probate. If don't have will, we call LA. But LA with will and next means I'm taking LA, but belakang I got will and next one. So why we have this situation? Granted, where there is a valid will but no proving executor, i.e., not willing to act or incapable due to insanity or old age or die before the testator. I can only remember this. I don't know. Maybe you can let me know more. What is this about partial intestacy? Okay. Then yeah. Anything else? Oh, sorry, I cannot share the notes because it's for sale. Sorry, guys. Anything else? Anything else you guys want to ask me? The testator missed out his property in his will. Oh, but that one I think okay. My practice and my understanding is that let's say I do a will. I say I got 10 properties. When you go to court, the court don't bother. The court won't check one. When you say you got this property, then it's up to you because when the court say yes, you got authorized, you got this power to manage this property. But in fact, you don't have this property. Land office won't lion you. So when you go to land office, the land office won't give you this land. So that's about it. So whether you mention something, the property not in your view or not, it doesn't matter. My understanding is like that. Ah. Anything else, guys? If no, then I will stop here. Let me see. Oh, yeah. Someone, yes. What you want to ask me? Oh, question A. Sorry, guys. I skip bankruptcy and winding out. So because those days also I not enough time to study bankruptcy and winding up. So I also just two land and one probate. So A, you asked me to wait Are you trying to ask another questions or what? Since the LPA has a new amendment regarding a short call application, aka now to apply within a month of privilege. Okay, I think I'm aware of the amendment lah, but I don't think it will affect the syllabus. What? Because I think they just write in the way that more clear about the timeline, all that lah. Do we need to cite the new amended statute or we just cite the old one? Okay. Correct me if I'm wrong if I didn't answer your question correctly. You see, we have LPA 1976. Then we have amendment, maybe 2024 or 2025. Amendment is not the principal act. The principal act is still the LPA 1976. It means that regardless we got how many amendments, the amendment will always go back to this principal act. So it means just because we have the Amendment Act in 2024, it doesn't mean you need to write Amendment Act 2024. No, you still write LPA 1976. Did I answer your questions? Okay, say that now is 2 million or 5 million. Yes, it's 5 million. The 2021 amendment, yes, I agree. I think they only come into force this year, I think, if I'm not mistaken, this year or last year. But now it's 5 million already. So anything else? So then how we answer, since the new amendment is 1 month, where else the old one is 3 months? Okay, if you want to be specified, then I think you can say with the amendment, the LPA privilege now is 3 months. Sorry, 1 month. Which means when you emphasize that, then you say it's a new one. But let me check whether it come into force already or not. I think it come into force already. Let me check. Yeah, it came into force already, the amendment in May 2025. So I think you can straight away just say LPA 1 month with the new one. Since it come into force already, means you don't need to mention the old one already. Okay. So I see. Does that mean the statute they give in the exam will be updated? Okay. This one, I heard there's no law says that. For my degree until CLP, my lecturer always tell us, the law, they will only ask 1 month or 3 months before the exam will be. Which means, if the exam is on August, by right, the latest law they can ask is only up to May, by right lah. This is what I heard only lah, but I don't know how true it is lah. So if you ask me, I think since you now aware already what the differences, then you just prepare for the new one. No? Since it's in May, it come into force in May. So by right, then you should answer whatever law up to May. This is my understanding lah, but my lecturer told me one, he never tell me the authority. Okay, so have a night. Okay, thank you guys. Hope you enjoyed the class. So I will see you next time. Bye bye.
Thank you, sir. Thank you.
Thank you. Thank you.